Okay, folks, we're now covering handout 16, which has to do with probate court jurisdiction in Rhode Island and in Massachusetts. In Rhode Island, the probate courts are created by statute by the legislature. They exist in each city and town. So every city and town in Rhode Island has its own probate judge, its own probate court clerk, and the courts meet at various times. In many of the smaller towns, they only meet once a month. The jurisdiction in terms of subject matter for the Rhode Island probate courts are as follows. The judges hear the probate and proving of wills. They handle the administration of the estates of people who died intestate. They handle guardianships of minors insofar as those are ancillary to a will where a guardian has been named by a deceased parent. In most matters that deal with children, their placement, and who will be their guardian or have control of them, the family court and the Department of Children, Youth, and Families have jurisdiction. However, under Rhode Island law, a parent can name a person that they propose as guardian if something should happen to the parent so that they have passed away and cannot take care of the child, and subject to approval by the Department of Children, Youth, and Families, if that is a suitable person, the probate court does have power to make these appointments for guardians. Adult guardianships. People who are not competent to handle their own affairs. These cases are brought also before the probate court in Rhode Island, along with change of name cases and conservatorships. A conservatorship is a case brought by a person who feels, even though they might be mentally competent for some reason due to illness or traveling abroad or something, they're unable to handle their own affairs, and they can ask the court to appoint a person to handle their affairs on their behalf. Lately, in the last 10 years or so, the legislature has created something called voluntary informal administrations and voluntary informal probates of wills, and these are to cover small estates where the rather cumbersome process of opening up a probate case or an administration would cost too much time and money and not really be worth it in the long run for the estate or for the heirs or for the creditors. All right, backing up a little bit. If someone dies with a valid will in place, they have died testate, the will must be presented to the probate court, and the will must be proved. So there has to either be the self-proving affidavit or testimony from the witnesses to establish that the will was properly executed and is the last will and testament of the decedent. If the court is satisfied that these criteria have been met, then the court proves the will, which basically is an Old English word for saying they have approved it, and that now becomes the official last will and testament of the person who has died. Along with proving the will, the court will also appoint an executor. Now, an executor is someone named in the will by the decedent to handle their affairs, to handle their estate. The executor must file something called a bond. A bond is their promise to the court that they will handle the assets of the estate appropriately, and that if they fail to do so, the court has the power to go after them and take their personal assets to make up for whatever was lost to the creditors or the beneficiaries. If someone dies without a will, they have died intestate, and the case that we would open in their estate is called an administration of an estate. In this situation, the court appoints an administrator. Now, because the person had not left a will, we don't have a named party to do this, so that the court can pick some suitable person to handle the estate of the decedent. Usually this is a family member, and the statutes in both Rhode Island and Massachusetts set out a priority of family members who the court can look to appoint. The administrator must also file a bond. With an administrator, sometimes the bonds get a little bit tricky. There are two types of bonds. One is just a plain bond, which is a signature of the executor or the administrator promising to handle the estate correctly. However, in cases where there is a great deal of money involved, or assets that could disappear easily, or where the court just has some question about the parties coming forward, they can ask for a bond with surety. A surety is a type of insurance policy that must be purchased to guarantee that if any funds are lost or mishandled, the insurance policy will pick up and cover the claim. Probate fraud and administration fraud was so rampant in Rhode Island 30-some years ago that the insurance companies basically stamped their feet and made it very difficult to obtain this insurance. It is expensive. It comes with all kinds of strings attached and all kinds of requirements that the estate must go through that makes the administration of the estate more expensive. So we try not to be in a situation where a bond with surety has to be provided to the court. Now, in a will, this is fairly simple because the testator can direct that whoever they name as executor they trust, and they request the court not to require a surety. With an administration, it becomes a little bit more difficult, and the lawyer representing the person coming forward to be administrator usually needs to have some arguments ready to say why this person is capable and honest and will handle the estate properly. I've said in the last 2 lectures that basically probate exists first and foremost for the claims of creditors, to make sure that the people who are owed money by the decedent receive fair payment for what they are owed, and then it takes a turn to worry about heirs and family members and people who are left behind, beneficiaries. As part of this process, several things happen in both probate of wills and administrations. The court sends the executor and or the administrator a form called an inventory and appoints them to be an appraiser. And as appraiser, they have to come up with a value for all the assets that are in the estate. They must list these assets on the inventory, and they are supposed to return that inventory to the court so that anybody who wants to can look at the file and can determine if there are any assets there or not. Creditors have the right to file claims saying that we are owed money by the decedent and we wish to be paid. In Rhode Island, claims must be filed within 6 months of the date that the appointment of the executor or the administrator is advertised in the newspaper. If you go look at the legal ads in any of the newspapers in Rhode Island, those little columns usually printed at the back of the paper, you will see that very often there'll be a listing from various probate courts naming the people who have been appointed to administer or to be guardians or to be executors of estates, and the powers of these people are dated from that date when this advertisement is made, and the time period for filing claims starts to run on that particular date. Now, under Rhode Island law, recently in the last 10 or 15 years, the legislature has also passed a requirement that says that it is up to an administrator and an executor to make reasonable attempts to determine who the creditors of the decedent are and to give them appropriate notice that the person has died and that they now must file a claim with the estate if they wish to be paid. And as part of the process of wrapping up the estate, the administrator or the executor is going to have to sign an affidavit under oath saying that they have taken this step and that they have made an attempt to discover and notify all known creditors. In most estates, if there are assets, this is not an issue because we make it very clear to the folks before they are appointed that their first job is to make sure that all debts get paid, and so the very beginning processes of handling the estate are determining what creditors are out there, how much they're owed, and as soon as we're up and running and able to distribute funds, to begin paying the claims of the executors. In Massachusetts, creditors have 1 year to file their claims against the estate, so it's a little bit longer than in Rhode Island. Many people complain about how long probate takes and the difficulties that are involved, and I would venture to say that in both Rhode Island and Massachusetts there are fairly streamlined processes for doing this. However, what people don't take into consideration is that sometimes there are things that become difficult. If there's a piece of property that needs to be sold, if one of the heirs or one of the beneficiaries challenges something that the executor or administrator are doing, if there is some dispute as to what the value of property is, or sometimes there's dispute as to what property actually is in the estate. If a man is married to his second wife and they own a house together with several $100,000 worth of furnishings in it, when he passes away, who owns those furnishings? Are they his? Are they the wife's? Are they jointly owned? Are they 50-50 owned? If the man had children from a prior marriage, very often they will come forward and make claims saying that the stepmother needs to turn certain assets over because those really belong to the deceased father. So there are issues that arise, and certainly when these issues arise, that stops the process dead very often until the issue is resolved, and they certainly have tremendously complicated ways of slowing things down and making them more difficult. So 95% of all estates probably go through very quickly. We're able to close them out within the statutory minimum period of time. We're able to pay the bills and pay out the beneficiaries and heirs prior to the date when the estate is officially closed. But those are not the ones you hear about. The ones that you hear about in the public mythology are the ones that become difficult. And again, usually they become difficult because there is some issue with resolving what property is in the estate. There are issues with back taxes, federal, state, or local that are owed. There are issues in terms of trying to sell pieces of property. And the estate must be kept open until all of those matters are resolved. In terms of appointing guardians, we'll talk about that at length for adults. In appointing guardian for minors, the person who is appointed is given the authority to control the health, education, and welfare of the child and to control their assets. There is a requirement that an accounting be filed annually in both guardianships for minors and guardianships for adults. So anyone who takes on that position as a guardian has to be made aware of the fact of that they now are basically in the position of a fiduciary. They're almost like a trustee, and that they have to keep track of every penny and be ready to account for that to the court. One of the things that I missed, probate courts in Rhode Island also handle the adoption of adults. Now, the adoption of children at this point in time is entirely relegated by statute to the family court. There is no way to adopt a child in Rhode Island without going through a family court proceeding, without the Department of Children, Youth, and Families doing a home inspection and an investigation to make sure that the adoption is appropriate for the child. However, there is a process to adopt adults. Now, somebody might ask, why would you want to adopt an adult? And olden times, this was a very important procedure, particularly for people who had no children, because you would adopt an adult and they would become your heir at law. And if you remember when we talked about wills, we said the English courts were originally very hostile towards wills. And if somebody was not your immediate descendant, your immediate blood relative, but you wanted them to inherit, you could make a will, but you always ran the risk that the court might find some technical reason to not approve your will. To seal the deal, in effect, what you could do is you could then adopt the person. This was particularly important if there were royal titles involved, so that if you were part of the nobility, or where you had duke or duchess or earl attached to your name, normally the only way that could be acquired would be by blood or by adoption. So the adult person that you adopted could receive not only your property and be the heir of your estate, but also could receive your title. The other items that are allowed in the probate court area in Rhode Island are change of name, so that anybody who wants to change their name, they can file a petition to do so. They must advertise in the newspaper to give notice to creditors that the person's name is being changed, so the creditors will know where to find them. They must obtain a BCI, Bureau of Criminal Investigation report showing their past criminal record. The change of name cannot be done for fraudulent purposes. It cannot be done to avoid your creditors. And if you are in a situation where you have been convicted of crimes involving embezzlement, fraud, larceny of money, it's very unlikely that a probate court judge would actually allow you to change your name for fear that you were doing so to defraud other folks. A conservatorship, as I said, is a voluntary placing oneself under the responsibility of the court, and particularly placing your assets there. These were common many years ago, and particularly they were common in the days when unmarried women had very few legal rights, and it was questionable as to what they actually could or could not do with their property. Today, I have never seen I've seen maybe one conservatorship in 40 years of my practice, and it's seldom done. But the statute and the ability to create one still exists under Rhode Island law. One of the big complaints about the probate process is that it is expensive. It takes time. There are court filing fees that are not that expensive. There are inventory tax fees to pay to the probate court to keep it going. There are also attorney's fees that most people have to pay because they find the process somewhat befuddling, and most executors and administrators are not willing to take on trying to bring the case through the process by themselves. In order to save the situation for very small estates, about 20 years ago, the state of Rhode Island changed its laws and created something called voluntary informal administrations or probates of will. And these are for cases where the entire probate estate is under $15,000 in value. They cannot handle real estate, and theoretically they cannot handle the transfer of motor vehicles. However, that is more observed in the breach than in the practice. I've seen many judges who will enter decrees allowing the motor vehicle to be part of the assets to be transferred. The whole purpose for doing this is because most situations where an estate is under $15,000, the probate fees and the attorney's fees would make it prohibitive to actually administer or probate those assets. So this is a way for folks where there is a very small amount of assets to take advantage of the court to get the proper documentation, because the party's in a catch-22. If grandmother dies with $3,000 in the credit union, that's a very small estate. It might cost you all of that money to probate it. However, the credit union, if her name is the only name on that account, the credit union cannot do anything with that money unless somebody shows up with a probate court document saying that, oh, I have been appointed to handle the affairs of this person. As part of this process, somebody must come forward and claim to be the voluntary executor or voluntary administrator. They must list the accounts or the assets under $15,000 that they will be dealing with. And there's basically one petition that's filed. The probate judge reviews it. Some of the probate judges require the persons to appear in court. Some of them do not. It's not required by statute. Some probate judges require that the petitioners show that the funeral bill has been paid in full, although that is not required by statute, and other judges do not require that. And if the probate judge is satisfied that this is a small estate, they basically sign the petition, and that becomes a document that allows the person to handle the affairs. Now, some of the things that happen in the probate court. Number one, as we said, bills need to be paid. There are priorities in terms of claims, in terms of items to be paid. And those priorities are set out by statute in both Rhode Island and Massachusetts, and they are fairly similar in both states. In Rhode Island, the basic priorities are, first and foremost, bills from your last illness, so hospital bills, medical bills, doctor's bills, ambulance bills, and your funeral bill. Take priority over all other matters in the estate. If somebody has come forward and paid those things on behalf of the estate, they now come first in line to make a claim and to be reimbursed for payment. The reason for this is obvious, that we do not want dead bodies piling up on the streets because nobody will pay to bury them, and we don't want hospitals and doctors to stop treating people who might be near death under fear that they would not recover for the expenses and the time and efforts that they have made to try and help the person or save them. After that, The next priority has to do with the administration of the estate. So probate court fees, attorney's fees for the lawyers involved in handling the estate come next. After that would be taxes. Fourth in line in Rhode Island is one called, you can actually make a claim for a family allowance. So twice within the probate process, a widow or widower and minor children of the deceased can come to the probate court through their representatives and claim that they need assets to live on, and above the claims of any and all other creditors, the probate court can issue them money from the estate that allows them to get by and to live. Now, certain things are exempt from the probate estate, so family Bibles, most household furnishings, clothing of the deceased, items like that, particularly if they are not of extremely high value or not even dealt with in the probate court. They are handled by the survivors among themselves. Creditors fall into two categories. One are secured creditors. So your bank that has a mortgage on the property of the deceased, the automobile loan company who holds the title to the car that is being paid for by through a loan or through a lease. Anybody who has a piece of personal property that the decedent has leased or has sold to, and he's making payments on it, so they have a security interest. Those folks are allowed at the point of death to take their collateral. So they can file claims with the court saying we want to be paid cash, but they don't have to wait for that. Once a person has died, if the estate is not able to continue making payments, then they are able to exercise whatever rights they have under their security agreements, and they can go forward and they can claim that asset and take it, so that that asset basically is removed from the estate by the secured creditor. Unsecured creditors stand in line. There are not a lot of priorities after we get through the list that I just stated. So basically, they wait to be paid. If the estate is insolvent completely, they don't get paid at all. If the estate is unable to pay all its bills, very much like bankruptcy, they would get paid on a pro rata share. And certainly, if there are sufficient assets in the estate, then these folks are paid, and only after that point, once all the dust settles and all the claims have been paid, all the bills have been taken care of, then we determine what is left to be distributed to beneficiaries or to the heirs at law. Now, Massachusetts has, again, as we stated in the last section, they have changed their laws. They have adopted the Uniform Probate Code, and by doing so, they have changed a number of things. First of all, there are no longer guardians, administrators, executors in Massachusetts. Everyone is now called a personal representative. In Massachusetts, there are basically two types of estates now. There are supervised estates and there are unsupervised estates. An unsupervised estate is one where everything seems to be in order. The heirs or beneficiaries are in agreement with the executor or administrator. They file the paperwork, everybody signs the appropriate waivers and releases, and everything is handled administratively by the court clerks, and a judge will eventually sign petitions, but you don't get to go before the judge does not hear testimony, and everything is handled pretty much as a administrative matter more than as a court matter. In a supervised estate, there is more control. You still may not get personally before a judge, or a lawyer may not get before a judge, but in a supervised estate there may be questions about the validity of a will, about who heirs at law are, about whether beneficiaries still exist or not, and it's basically an estate that requires more attention from the court and would require that a judge review and look at certain things and make a decision that certain aspects can go forward. So it's a little bit different than Rhode Island, and whether you choose a supervised or an unsupervised estate is something that when somebody dies, their heirs, their beneficiaries, executors would need to discuss at length with their attorneys to determine what is most appropriate, and very often that has to do with the nature of who are involved as heirs and beneficiaries, what are the nature of the property involved, is the property in more than one location in Massachusetts or in more than one state. Those are all questions that will go into determining whether or not you have a supervised or unsupervised estate. After that, the process is fairly similar to Rhode Island. There are inventories that have to be filed, bonds that have to be filed. There is an accounting that would have to be done at the end. In Rhode Island, to close out an estate, there are basically two ways you can do it. One is by filing an accounting, whereby the executor would have to account for every penny of assets that came in and then state to the court where they went out. The accounting would be prepared and set down for hearing. It would be sent out to all interested parties, and any interested party would have the right to object. If they object, there will be hearings on the accounting as to whether things were appropriately done or not, and whether assets should be given to one person or another. If there are no objections, the court can just approve the accounting, and then the estate is closed. The administrator, executor, is discharged at that point, and they have no further duties. If there are no arguments, if everybody is in agreement, the heirs and the beneficiaries, about what should happen in an estate, then in Rhode Island, an estate can be closed by something called affidavit of complete administration. It's basically an affidavit signed by the executor administrator under oath, stating that all bills have been paid, the funeral has been taken care of. You must provide a receipted funeral bill. You must provide a statement from the Division of Taxation saying no inheritance taxes are due. You must have releases from all beneficiaries saying that they have been paid and are satisfied and are not contesting the amount they are paid. You must have releases from any creditors who filed claims during the process. If you have all those documents in place, the executor administrator can swear under oath that they are done their duties, that the estate has been administered and dispersed, and the court will enter that in the court file, and that will work to also close the estate and discharge the executor or the administrator. In Massachusetts, the probate courts act a little bit differently than in Rhode Island. In Rhode Island, the probate courts in the local cities and towns are courts of first impression. They can handle down decrees as long as there is no objection or contest to their decision. If a party objects or contests, then any party so aggrieved has the right to appeal to the Superior Court in Rhode Island, where they can actually request a trial de novo, which means the whole process begins in Superior Court, and the Superior Court will ultimately hand down decisions on any contested matter. The Massachusetts probate courts are vested with the power of superior courts right from the beginning, so that they make the final decisions in all probate matters. In Massachusetts, they also handle juvenile criminal matters, and they handle divorces. So they are much more active in acting as superior courts, where there are witnesses in trials and hearings and motions, much more so than the probate courts are in Rhode Island. All right, I think that pretty much has everything I want to say about probate courts and probate processes in handout 16. On handout 16A, I want to go a little bit into more detail about adult guardianships in the state of Rhode Island. These are a little bit complicated and have to be done exactly correctly, or the parties will end up repeating the process several times, causing a great deal of grief, delay, and expense. In order for an adult to be placed under guardianship in the state of Rhode Island, it must be determined that they are not mentally competent to handle their own affairs. The first step that must be taken is to obtain something called a decision-making assessment tool. A DMAT is a form that is created by the probate court, and it must be completed and filled out by either a doctor, a psychologist, a nurse practitioner, or a licensed social worker, and it must in detail describe the mental, physical state of the proposed ward and make some type of determination based on a medical basis that this person is not able to handle all or some aspect of their own affairs. This is jurisdictional. By statute, the legislature has determined that if you cannot get a doctor or other professional to sign a DMAT, you cannot go forward on a guardianship of an adult. So very often when people come and say to me, a relative, my parent, my grandparent, an aunt, an uncle, or a child with disabilities is now becoming an adult and we need to have them under a guardianship, very often the first thing that happens is we hand them a printed copy of a blank DMAT and tell them you need to go get this signed by somebody, one of the different types of people on this list, and until you come back with that, there's absolutely nothing we can do with you. In most cities and towns, the judge will not even accept the petition, the clerk won't accept the petition for a guardianship until the DMAT is completed and handed in as part of the initial filing. The petition for guardianship is filed in the city or town where the proposed ward resides. There must be a copy of the ward's birth certificate filed with the petition, and in the petition you must name who the person or persons are that are seeking to be the guardian of the ward. Now, in Rhode Island, guardianships of adults can be very interesting because they can be limited guardianships or they can be full guardianships. A full guardianship says that whoever is appointed guardian has the right to control the person and the property of the ward. So that would mean all their financial matters, their social living arrangements, who they associate with, their medical care. All of that would be under the purview of a guardian in a full guardianship. If such a broad treatment is not necessary, then we can have limited guardianships for particular purposes. Limited guardianships to give consent for medical procedures, limited guardianships having to do with housing and social contacts if the person has no assets, or a limited guardianship just to control assets if the person is highly functional and is able to pretty much move around in society and deal with things on their own, but is not able to competently handle their money. The goal in Rhode Island, the rule in Rhode Island is the court is only supposed to impose the least restrictive guardianship possible on the ward. And part of the DMAT and petitioning process is the proposed guardian has to state, are there any other alternatives such as powers of attorney or trusts that could be utilized or have been set up that might be able to allow this person to continue to live without having to be under the constant supervision of a guardian or of the court. Once a petition is accepted for filing, the court appoints someone called a guardian ad litem, which means guardian for the litigation, guardian for the case. Traditionally, these were attorneys, although now there are several groups that offer professional guardian ad litem services, and they usually train social workers, psychologists who know about guardianships, know about the law, know about disabilities. And what happens is one of these people are appointed, and they are sent out by the court to interview the parties involved to determine as an independent third party whether a guardianship is warranted or not. This rule is a result of many years ago. It was very easy to get a guardianship over somebody, and once it was set up, it was very difficult for that person to then get out from underneath the guardianship. So because of abuses in the past, we now have this system which is somewhat difficult for families to deal with, particularly if the need for guardianship has come about as a result of an injury or some type of sudden illness. So now the family is dealing with medical crises and emergencies, and now we have these attorneys popping around the place, both their attorney that's working with them to file the petition and now this third party. By statute, the guardian ad litem has to see the ward, has to interview the ward, and attempt to explain to the ward that the ward has rights to challenge this guardianship, to have an attorney appointed for them if they have no money, and to review any paperwork, any claims that have been filed against them. It's almost like a mini Miranda rights for those of you who are familiar with criminal procedures. Before the case can go forward, the guardian ad litem has to report back to the court that they have met with the ward, they have explained the ward's right to contest, to show up in court, to demand that the guardianship be limited, to demand there be no guardianship at all, to have a lawyer appointed for them. They have to state that they've discussed all of this with the ward and basically attempted to make the ward aware of these things. The guardian is also required to interview the guardian ad litem is required to interview the proposed guardian, and sometimes the social workers, the doctors who sign the DMAT, other family members, to get an idea of exactly what services are required by the proposed ward, and to make sure that the parties are not overreacting or overreaching in the situation. In order for the court to have jurisdiction, a sheriff or constable must serve the proposed ward, must read the petition to them, and again, make it clear to them that they have the right to file an objection and to oppose this petition and to oppose being placed under the guardianship. Again, within families, this often is very awkward and very difficult, but they are requirements of the law to protect people from being placed under guardianships when they do not need to be under guardianship, and to protect people from being placed under a guardianship unscrupulously. If you wish to be a guardian, one of the things that you must do in Rhode Island is you must obtain a BCI report. Again, as we talked about previously, you must go to the Attorney General's office, to your local police department. Your criminal record is looked up and reviewed and printed up, and this must be submitted to the court. And if there is any indication at all that you may be a danger to this person, that you do not handle money well, that you have been involved in fraud or embezzlement or other types of financial crimes in the past, you will not be appointed a guardian. A guardian in Rhode Island must also file a bond. They must make a promise to the court that they will act as a fiduciary and that they will handle the financial matters of the ward only for the ward's benefit and not for their own. Having said that, guardians can claim reasonable compensation for their services, although this is totally under the jurisdiction of the probate court judge in guardianship matters. In the handling of estates and administrations, it can be worked out between the executor administrator and the heirs beneficiaries as to what fees will be charged by the executor administrator. The court has less jurisdiction there to control, although some of the judges try to control that also. But in guardianships, there is a public aspect to this, where it is the judge's duty to protect the ward, and most of them are very adamant about reviewing bills handed in by the attorneys for the guardianship and by the guardians themselves to make sure that the ward is not being taken advantage of. The guardian must file an inventory. They must also keep an accounting and file it each year with the court, and that accounting must have a record of all funds that came in and were expended on behalf of the ward. Every year, they must also file something called an annual assessment report, which is basically a status report about the condition of the ward, where the ward is living, what progress or what setbacks have occurred with the ward during the last year. So the court basically has some idea as to what's going on with this person who is technically under the jurisdiction and charge of the court at this point in time. Some judges will allow the annual accounting to be waived if the estate is of low value, or if the ward is somebody who's living only on Social Security, disability, or some other type of set income. For Social Security, disability, and Veterans Administrations, if the guardian is also the payee, there are reporting requirements that have to be made to these agencies, and many judges take the position they don't need to replicate that and duplicate that, creating more expense and lost time for the guardian and for the ward. The annual assessment report is almost never waived. I've never seen that done. The guardian must each year advise the court as to what is happening with their ward. All right, I believe that's everything I want to say about probate court jurisdictions. The guardianship process in Massachusetts is fairly similar to Rhode Island with a few differences, but same basic ideas, same basic concepts apply. All right, we will end this now. We're going to go on to handout 17.